member. I'm pleased to have this opportunity to speak with you addressing proposed bill 446. I will have a suggestion as to how domestic workers, starting off point for defining domestic workers. I have submitted written testimony, which I'll try to summarize. I speak to you, however, in my role as general counsel for a large employer. Prior to that, I was in private practice for 25 years. So it may be difficult for me to summarize my comments. As a lawyer who usually bills by the hour, I tend to say too much rather than I will. Companions and Homemakers is one of Connecticut's largest providers of non-medical domestic services. That's home care for seniors throughout Connecticut. We were founded in 1990. And in those 25 years, we've had many opportunities to examine the issues of domestic service and domestic employment from many perspectives, three in particular. The first perspective is the income-limited senior who needs home care services. The second perspective is the hard-working domestic worker who we believe deserves protections equal to no more, no less than any other industry. And the third perspective is that of a business that provides employment for thousands of domestic workers while balancing the expense and the need to comply with each and every labor law, which we do. Those experiences over 25 years, however, don't make it easy to speak to proposed Bill 446 because in its present form, it's less than 30 words. But there are 2 points I can raise with regard to that bill. The first is, as I know distinguished members of this committee are very aware, in the last legislative session, Special Act 1417 established the Domestic Workers Task Force. We've heard that mentioned today during testimony from the Permanent Commission on the Status of Women. That commission, that task force is hard at work. It's very capably led by Representative Terziak and Senator Winfield. And one of the things that that panel is tasked with, if I may take liberties with that, is defining domestic worker. We're at work on that. Our report has to be filed later than October. So I would respectfully suggest that since that hard work is being done, that there's no need to further define domestic worker right now. The second and probably predominant point of my testimony is to suggest, in the event that this bill does evolve and define domestic worker or enable additional protections for them, is a starting point for the definition. We have heard a good deal of testimony today from individuals, many from an immigrant community, talking about the abuses that are suffered when working in an individual household predominantly employed by individuals as opposed to agency employers. That theme also played out in a public hearing that the Domestic Worker Task Force held. And the evidence demonstrated that not all domestic worker employment situations are created equal. There are really two kinds. One are the agency-employed domestic workers, whose agencies already are inspected by OSHA, are policed by the EEOC, CHRO, the Justice Department, employers that pay into the Workers' Compensation Insurance Fund, into the Unemployment Insurance Fund, that fund health care under the Affordable Care Act. In other words, those are employers that treat their employees with dignity, pay them appropriate wages, and give them full protections. I'll try to summarize my remarks. Thank you. The secondary force of domestic worker labor is that, again, which testified today. Individuals employed in individual homes, often outside of the purview of appropriate law enforcement agencies. Often individuals who encounter a language barrier, individuals new to the country, unaware of their rights, or unaware of the ability to access or find help in the event that they are being exploited. The key difference is the employer, not the worker. The agency employer already protects their workers. The individual household may not. So I suggest that if you are going to define domestic worker, that that's a good starting point. And actually, the task force had its origins in substitute bill, I think it's 5527, pardon me, yes. And that bill originally had a form of definition for domestic worker that is very much along the lines of what I said. It separated the worker by who their employer was. So in this regard, I do suggest that you delay any further acts to define domestic worker until the task force completes its work. And I ask that if you do define domestic worker, that you consider the starting point that I put forth here. If you have any questions, I'm happy to address them, but most of all, I know it's late. I salute you for your stamina and for your attention to this matter, and I thank you for your time.
Thank you, Attorney Denvir. Are there questions from members of the committee? Representative Luxembourg.
Thank you, Mr. Chair. Just a quick question for me. From your perspective, why is it important that your employees not be classified as domestic workers?
Well, Representative Luxembourg, thank you for the question. There are really two reasons for that. The first is that efforts that I have seen put forward in legislation and have been advanced in other forums to group all domestic workers under the same umbrella, in my opinion, are improper, because as my testimony supports, and as we've seen through the testimony of others today, not every situation is the same. The proposed domestic workers Bill of Rights that I've seen, for example, would protect domestic workers by being the only industry in the country that has mandatory severance pay, the only industry in the country that has mandatory vacation pay. And I think with regard to domestic service workers, it would be particularly inequitable to do that. For the second reason, I don't think they should be considered domestic workers. And that concerns the care plan for seniors as it exists throughout the country currently in the state of Connecticut. I've illustrated that. Connecticut provides home care services to thousands of seniors under what's called the Connecticut Home Care Program for Elders. That is a Medicaid-funded program, half paid by the federal government, half paid by the state. And many providers, such as my company, Companions and Homemakers, serve seniors under that program. The expense of that program is such that providers are being driven from it. They're at the tipping point where one more financial burden of having to, for example, provide severance pay or mandatory vacation pay could cause many providers to withdraw from the market. And I'll give you 30 seconds worth of figures to demonstrate the severity of that. We estimate that participation in the ACA costs approximately $400 per month per employee. We don't mind paying it. We've provided a health plan for our employees for more than a decade, long before the ACA. Minimum wage in January just went up by 40 cents. In January, it goes up by another 45 cents next year. In the last 7 years, the Medicaid reimbursement rate that is paid to providers in the home care program for seniors, or for elders, excuse me, has gone up once in 7 years. That increase was 15 cents an hour. So if you factor in the additional expenses that these providers have incurred in just the last 12 months alone, there's just no margin left. They can't afford to participate in the program, which means thousands of seniors will lose their care. So those are some of the reasons that I don't think that agency employees should be considered domestic workers.
Are there other questions? If not, thank you very much for your testimony.
You're welcome, and thank you.